Good morning, my dear students and dear viewers. ಎಲ್ರಿಗೂ ಮತ್ತೊಮ್ಮೆ ನಮಸ್ಕಾರ, ಸುಸ್ವಾಗತ. ನಾನು ಡಾಕ್ಟರ್ ಸಜ್ಜಾದ್ ಪಾಷಾ, ಗವರ್ಮೆಂಟ್ ಫಸ್ಟ್ ಗ್ರೇಡ್ ಕಾಲೇಜ್, ದೇವನಹಳ್ಳಿ. Now the presentations are going on relating to the chapter Indian Contract Act of 1872 of the subject Business Regulations of third semester BBA. Now this is the session number 14 on the topic legality of object. Legality of object. We have been discussing from the previous discussion, the previous sessions on various essentials of a valid contract. Unless and until essentials are fulfilled, nothing but the conditions are fulfilled, a contract or an agreement cannot be a valid one. So a valid contract, a valid agreement must have certain essentials, must have certain conditions. One such condition is now going to be discussed, that is legality of object. As I told, it is another important requirement, another important condition of a valid contract. If the object of a contract is not legal or opposed to the law of land, the contract is unlawful, or it can be simply considered as a void contract. So the objective, the purpose of the contract must be lawful, must be legal. It should not be an unlawful, or it should not be an illegal one. This is again an important condition to be considered while entering into contract, while making an agreement. To know about the lawful agreements or the legal contracts, we must also aware of unlawful agreements, because when unlawful agreements are avoided, when unlawful illegal contracts are avoided, then naturally there will be lawful agreements and lawful contracts. Sorry. Section 23 of the Act has certain considerations and objects of an agreement are declared as unlawful. Means Section 23 has prescribed what are the agreements which are considered as unlawful. According to this section, the agreements or the contracts are lawful. The agreements and contracts are lawful unless they are forbidden by law. They are of nature that, if permitted, would defeat the provisions of any law. They are fraudulent. They involve injury to the person or property of another, or the courts regards these as immoral or opposed to public policy. So if the contracts or the agreements do not contain these five aspects, five components, then such an agreement or contract becomes lawful. So when a contract is forbidden by law, prohibited by law, prevented by law to be entered, then it is unlawful. Such contracts cannot be a valid contracts. Similarly, if the contracts are of nature that, if allowed, if permitted, would result in the defeat of the provisions of other laws, provisions of any other law. So, allowing of one contract would affect the existence, would affect the provisions of other law. Such laws, such contracts and agreements are also unlawful. Then, when the contracts are fraudulent, when the contracts are fraudulent means when a contract is uh, started, when a contract is entered into, when a contract is executed through frauds by a fraudulent means, then such a contract is unlawful. So, a contract must not have been brought into existence, brought into between the parties through a fraudulent mode. So there should not be, in the previous session we had discussed that the frauds, misrepresentations, misstatements of fact also leads to not a free consent. And when the consent is not free, then the contract based on which is also a void one. So that is why the contracts should not be the contract should not be entered through fraudulent means. Then, if a contract involve injury to the person or property of another, then such laws are also unlawful. Such agreements and such contracts are also unlawful agreements or contracts. If any contract does not involve any injury to any person or does not affect damage to the property of other persons, then such an agreement will be a valid one. Then, if the courts regards any agreement, any contract as immoral or opposed to public policy, then such contracts are also unlawful contracts. So, an agreement or a contract must not have been declared as immoral, must not have been regarded as opposed to the public policy of the land, public policy of either the state government or the the central government. Okay, so these are the five types of contracts which are unlawful. If these five uh, aspects are not available in any contract, then these contracts are legal and lawful. I hope all of you might have understood the significance of the legality of object, the purpose, why the contract is being entered into, why an agreement is being made between the parties. The purpose, objective of the contract, objective of the agreement must be fully legal, must be fully lawful. If not, such an agreement or contract becomes unlawful and that is void in the eyes of law. Thank you. Thank you so much for viewing this session.